Hi, I'm Ben Doyle from Lamb Chambers. I'm here with James Culverwell and Matthew Gillett. We're all junior barristers at Lamb Chambers in the property team, and we want to talk to you today about the impact of the coronavirus pandemic on residential possession proceedings. So this talk is more aimed for landlords and those instructed by landlords, but we think that the talk would also be useful for tenants and those instructed by tenants. So the coronavirus pandemic has led to a new act, the Coronavirus Act 2020, and a new practice direction 51Z to the civil procedure rules.
Yeah, so the effect of both of those are that basically it's very difficult to start or bring possession proceedings at the moment. Practice direction 51Z stays all possession proceedings, so you can issue them, but they will automatically be stayed, and that has just been extended for 2 months. So certainly for the foreseeable future, that's going to remain in place. That has been tested by the Court of Appeal, of course, in Arkin and Marshall recently, in which it was decided that it wasn't beyond the powers to put those measures in place. The other matter that Ben mentioned was, of course, the Coronavirus Act, which doesn't affect proceedings but affects notice periods, and that the effect of that act is to extend all notice periods for residential possessions to 3 months. So, for example, Section 8 notices, which were 2 weeks, are now 3 months, and Section 21 notices, which were 2 months, are now 3 months. And that also deals with other less well-known residential tenancies, such as protected tenancies, secure tenancies, and so on. But those aren't so common, so we probably won't deal with those in very much detail. Matthew, do you want to talk a little bit about what people might do in terms of serving notices?
Thank you, James. There are practical consequences as well, of course, with the coronavirus. Any service attempt has to be done in accordance with the government guidelines, social distancing, and so on. As has been discussed previously at Lamb Chambers talks on residential possession proceedings, you have to get the notice right before you serve it. You don't want to commence things on a defective notice. When it comes to the service itself, it's always advisable to go first class post and recorded delivery. Nowadays, of course, the expectation would be much more that people are in to receive the mail, but it's still best to have some proof that you can put before the court to say, to prove that you have attempted service and it has been delivered, so that you don't hit that hurdle. Because, of course, with all these stays and no possession proceedings going on, when the courts do reopen, there's going to be a huge backlog of cases. And the last thing you want if you come to having issued proceedings is to have to go back to square one because service was defective.
Yeah, absolutely, Matthew. And I think an important point here as well is for landlords to decide actually whether they want to serve notice at the moment. Because, for example, if they want to bring a Section 8 claim for arrears of rent, it might be better to wait because assuming that Practice Direction 51Z does end and the stay ends in August, if once notice periods go back to 2 weeks for arrears-based claims, if you wait until then you're going to have a lot more arrears potentially than you are now, which is going to offer you some more protection against, for example, a disrepair counterclaim.
Yes, and you've got to think about whether you even wait until October, which is the current planned end of the extended notice periods to serve. And I think what we've spoken about previously is whether I suppose it's a balancing act now, isn't it? If you serve now, you've got a 3-month notice, but that will expire from now in September, say. But you probably, well, we don't know whether you'll be able to bring proceedings at that point, but at least you've served your notice, you've got it out of the way. But I think the closer you get to that October deadline, which is the current deadline for when notice periods go back to normal, the more sense it makes to wait until that notice period reduces to 2 weeks again in the case of Section 8 notices, of course, because then for example, if you serve a 3-month notice in September, that's not going to end until the end of the year. Whereas you wait a few weeks and it's October, it's back to 2 weeks, you can serve it, and it's a 2-week notice, and you jump the queue somewhat. So I think it's a bit of a balancing act now, and you've got to judge it on what the level of arrears are, and so on. And I think the closer we get to the deadline, the more sense it makes to wait.
Absolutely. I think the Section 21 position is slightly different because, of course, it's a longer notice period without the COVID Act extension. And, of course, at the moment, if the original period has already lapsed and you're able to serve Section 21 notice, there's no real reason to wait. Only more cases will get ahead of you in a very long queue. So you may as well probably go with those early, whereas with the Section 8 notice, there may be another advantage of waiting, which is to allow the arrears to increase so that there's no chance of matters being adjourned with tenants having paid a nominal amount to get the arrears back under the relevant thresholds.
Yeah, I think that it's a good point to mention Section 21. And I think probably the other thing to mention, although it hopefully should be obvious to landlords, is to make very sure that you have your house in order before you serve the Section 21 notice. So you need to make sure you've got your EPC, you've got your gas safety certificate, and you've complied with the rules relating to tenancy deposits. Now, this is really a topic for a different talk, but landlords should be aware that there are many procedural requirements, and there are several new requirements this year. So your EPC, I suspect, if it's not Band E, you might run into difficulties there. That's a new requirement from this year. So make very sure you have your house in order, take legal advice before you serve your Section 21 notice, because the last thing you want is to serve your notice, eventually come to court, as James said, with a huge backlog of other cases, and find that you've got fundamental problems with your claim. Yeah,
and then you're back to square one.
Exactly.
Yeah, so that's absolutely right. There are a couple of things, as you said, Ben, that's a separate talk really, but there are a couple of headlines to think about. Obviously, deposit protection, in a way, if you've got any concerns about that and you're desperate to get possession back, you're best off just returning the deposit, and then you sort of circumvent that. It may seem like a risk, but it's much better to do that and get possession, I think, on balance, than try and keep hold of the money, because potentially you may have some concerns about the state of the property, or you're owed a little bit of rent but not enough for Section 8, and so you hold on to the deposit, but you get to court and find out that you've missed one of the very small technicalities that you have to, all of the many hoops you have to jump through for Section 21, and you're back to square one. So that, in that situation, it's best to just return the deposit and then serve your notice. I think the other matters, such as that you mentioned, Ben, EPC, gas safety, excuse me, how to rent, booklet, and so on. Check through those, serve them if you haven't served them before considering serving Section 21.
There is, of course, the new requirements as well, which are the subject of a talk by one of our colleagues in Chambers, available on the Lamb Chambers website in the podcast format, for the current or the most recent landlord obligations that, of course, still have to be complied with. So it's worth checking out for a fuller investigation of that area.
Yes. In terms of actually serving the notice, I suppose that's something to think about. That's something that Matthew, you touched on, but it's probably worth thinking about, not just obviously serving it by first class and recorded delivery, but checking the tenancy for the actual, what the contract says about service. It may be that there's an easier or more onerous duty on you in terms of service, and it may be that you get deemed service under the tenancy. That's often a provision that's provided for, and actually in the current situation, it may even be easier to get personal service or recorded service, because I'm sure everyone has had things delivered to them, and you don't, obviously there's no signed for now, but delivery drivers will simply leave it on the doorstep and take a picture, and that can be and that will be evidence that it's been delivered, which in fact, when one thinks about it, is probably good practice anyway, if delivery drivers were to do that, because it means you've got very easy evidence that the envelope or the package was taken to the door. So I think if that continues, that's probably only going to be a good thing.
Yeah, I think it's also probably worth, you can think about using a process server. The advantage of process servers obviously is that they have no interest in the proceedings whatsoever, so their evidence is likely to be taken to be truthful. If you're getting an estate agent or a letting agent to deliver it, I think a good point here is to actually get a certificate of service from them straight away. I've had cases where the person who delivered the notice has subsequently left the firm, and so by the time it comes to court, you can't get evidence of the service, because often even service of notices will be disputed by the time you get to court. So you want to make sure that you're able to evidence that it has been served. And I think it's a good point, as James said, check the tenancy, check you've got a deeming provision, and see if there's a contractual means of service that will try to make sure that you're watertight on service. So I think having served your notice, your next tactical decision, and this has been touched on earlier, is when you want to issue. So probably having served your notice, you're going to want to try and issue so as to avoid being too far back in the queue. We do anticipate, I mean, no one really knows, but we do anticipate that there will be a huge backlog of cases when the courts start dealing with possessions again. So it probably is worth issuing in most cases fairly soon.
Section 51Z came into force on the 27th of March and is due to expire on the 27th of August. So there's 5 months worth of cases there that haven't been heard, haven't been determined. There's then all of the other uncertainty, of course, which is going to be readily accessible for everyone, which is that people have unfortunately lost jobs. There's been a huge downturn in the economy. That's going to put more people into arrears, of course, with the passage of time. More Section 21 notices will be able to be served. So the queue is going to be monumental, and how the courts propose to deal with the backlog, it remains to be seen. I know a working group's been set up to try and alleviate any problems, but that remains to be seen how it can be done, because technology isn't really going to be as suitable in this area as it is in other areas of the court's estate, because so many defendants require advice in person on the day from a duty solicitor, which isn't, it's not easy to interface with them on a Zoom call before coming into the court. And so those logistical matters mean it's going to be more likely it's going to have to be in-person hearings, and how the court can clear such a backlog, which comes back to what Ben and James have been saying throughout, which you've got to get your house in order, because chances are judges may well just see any mistake and say, well, you haven't done it, I haven't got time to grant you further relief or give you a second chance. You had a chance, you got it wrong, back of the queue. So it's something that has to be borne in mind in these times.
Absolutely, and when that, not just notices, but of course your pleadings for possession are vital at that stage. And I think we all agree that one of the most common issues that we come across that leads to a claim being struck out, or even if it's not struck out, causing a significant delay, is that the statutory grounds aren't pleaded, and that is absolutely vital. It is part of the procedural rules. I think it's one of those things, it's not particularly helpfully highlighted in the standard form, claim form for possession proceedings. I think that, which is often what I think leads to that being missed, because it doesn't particularly say which statutory ground are you relying on, but there is space to do it and it needs to be done. And I think Ben and Matthew, we've all had cases where judges have highlighted that, and generally it's an adjournment to replead and reserve potentially, but it can be a strikeout, and then again you're back to the back of the queue. And as we said all along, that queue is going to be incredibly long when possession proceedings start going ahead.
Yeah, I think it's a very good point. It's something I've seen many times. I think it's section 4C of the particulars of claim, the prescribed form. So if you're relying on the usual arrears grounds for a Section 8 claim, 8, 10 and 11, you just need to plead that you're relying on grounds 8, 10 and 11 of Schedule 2 of the Housing Act 1988. It's something that's very often missed, and I absolutely agree with James. It's not very helpfully set out in the form, and I think the notes that come with the form aren't very helpful either, but it's something to be aware of.
Yeah.
Anything to add on that, Matthew?
No, just again, just make sure it's all accurate. There's obviously lots of it's just a long box ticking exercise in terms of the notice and the proceedings and making sure service is done and making sure the certificate of service. So just making sure that each box has been ticked appropriately as you go along with all the relevant information, because right now the stakes are even higher. Any mistake, the consequences are even greater than they used to be. So certainly got to be very careful, with great attention to detail on doing those bits of paperwork.
Yeah, absolutely. I think one other point maybe to mention is for Section 21 claims, a new prescribed form came in June 2019, which adds in the notes section a note F about compliance with the Tenant Fees Act. So again, it's something that could very easily be missed. I've seen cases where the previous form, which is almost exactly the same, has been used. But again, it's just a way in which your claim might be invalidated. So just do everything you can to make sure that your house is in order. We're here to help. Our details are available on our website, lambchambers.co.uk. We'll be doing other videos about other types of residential possession proceedings and possibly focusing on the commercial side as well. And as Matthew said, look out for videos done by our colleagues at Lamb Chambers. We hope this talk's been informative, and we'll look forward to having contact with you soon.